employee drug and alcohol testing. And the primary panelists for this topic are going to be Mark Garner, Mike Cluck, and Cliff Hammond. And we are going to start this off with Mark giving us an overview of employee drug and alcohol testing as it exists today.
Thanks, Mike. One of the again, I'm Mark Kerner, and one of the things that we wanted to talk about today was some of the changes that have happened in the law with respect to drug and alcohol testing. One of the most significant changes over the last year is that the Department of Transportation has authorized the use of oral fluid testing for marijuana and other controlled substances rather than using urine testing. And it's the oral fluid testing essentially is a test that provides greater accuracy or a window of when the use occurred instead of a urine test, which would provide up to a week or longer depending on the individual's habits and use. Oral fluid testing gives positive results from a 24 to 48 hour window, thereby taking away some of the issues with drug testing. An employee, say on a Monday, who has used marijuana or some other substance on a Friday and still shows up in their system. Under this test, if within a 48-hour period, it may no longer appear in their system. So it eliminates some of that, not when an employee is not impaired by the substance, but they still have them in the system and then subject to discipline. Several states are actually starting to use the oral fluid testing for impairment testing for road drivers. A lot of it's in the beginning stages, but the Department of Transportation has indicated that the testing that it is permitting and allowing is not an impairment test. It said basically the DOT testing program is a deterrence-based program to prevent illegal drug use, not to prevent or not an impairment test. So pursuant to the DOT rules, the presence of marijuana in your system, they aren't looking at it in terms of whether or not you were impaired by the marijuana. They're still looking at it in terms of whether or not the person has it in their system and therefore would be subject to discipline. With the oral fluid testing, employers get to choose the methodology for the regulated drug tests. They can be pre-employment tests, random tests, reasonable suspicion tests, post-accident tests, or follow-up or return to duty tests. The employer also gets to choose the methodology for those tests. And in other words, an employer could start with an oral fluid test, and if it's determined that a urine test was necessary, they could do a follow-up test with the urine test. That's the collection method is always left up to the employer pursuant to the new rules. And again, for instance, if you start with a urine test, you get a shy bladder result or some other dry mouth issue in an electronic breath test, you can move to the oral fluid testing for the backup. The oral fluid testing rules became effective back in 2023, but unfortunately, they're still not permitted to be used or implemented. And this is because the DOT has said that the Department of Health and Human Services has to certify at least two laboratories for the testing. One would serve as a primary laboratory and one would serve as a split specimen laboratory. And that hasn't been completed to date. So even though they approved the use, it's still not allowed to be used in the testing at this time. There was some recent changes to the oral fluid testing rules. They had to make a modification to the qualifications of what would permit somebody to be a qualified collector. And this is because before oral fluid testing became available, there were no qualified collectors. So they can't actually approve someone to be a qualified collector because there aren't any. So they've reduced the qualification requirements so that we'll have the ability to make more people qualified collectors. There's a sunset provision on that. I think it's a period of a year. After a year, the qualification requirements are going to go back up because we'll have people that can verify and help qualify you as a qualified collector. The increase in privacy components to oral fluid testing in the DOT environment, that only the employee, the collector, and a DOT representative can be present for the collection. Then it puts some clarification out there about how the collector designates the sufficient amount of collection amounts within the testing process. And those changes to the DOT rule became effective August 5th. Another significant change in the testing world, and it's not actually complete yet either, is the reclassification of marijuana. Earlier this year, the Department of Health and Human Services, at the direction of Joe Biden, requested that marijuana be reclassified from a Schedule I narcotic to a Schedule III drug. That needed to be approved by the DEA. The DEA shortly thereafter had indicated that it was in agreement with the process, but was going to put the process through the rulemaking procedures. Therefore, an actual determination on whether or not it's going to be rescheduled from a Schedule I to a Schedule III won't likely occur until sometime after the elections, which may change the DEA priorities. However, I believe that there's currently there's hearings that are scheduled with all the stakeholders in the process for December of 2024. If it is if marijuana is rescheduled from a Class I, Schedule I drug to a Schedule III drug, it takes it out of the or the areas of heroin and cocaine, which are considered extremely addictive with no medical benefits, and puts it into classification with other drugs like ketamine, Tylenol with codeine, anabolic steroids. Those are drugs that are classified as drugs that do have a potential for abuse, however, does acknowledge their medical benefits. The schedule, if the reschedule goes through, people think that that's a road to actually making it legal. It doesn't actually do that per se. What it does, it doesn't fix the gap between federal and state law. For instance, currently Michigan has the law that says that you're allowed to use recreational marijuana if you're 21 years and older, without a prescription. If marijuana is rescheduled to a Schedule III, generally those drugs still require a prescription before they can be dispensed. So there's still going to be that gap between the two. Ultimately, it would allow some tax benefits to growers of marijuana that they currently aren't provided because of the fact that it's currently a Schedule I. But those changes, again, haven't gone into effect yet.
Okay, Mark, one of the questions that came in is with the oral fluid test, is MRO verification still required?
Yes, MRO verification would still be required.
Okay.
And as previously, so for instance, when the state of Michigan and several other states allowed marijuana use, the DOT said that it didn't care what the states had done. If there was a positive test for marijuana, the MRO was required to classify that as a positive test, even if the person had a medical prescription or it was legal within their state. I think that part of the issue with the Schedule III is that if it gets reclassified as Schedule III, the MRO would still have to certify a positive test, but there's different rules and regulations because it's something that you could potentially have a prescription for. But yes, it still requires the certification by the MRO.
Okay, thanks. And a follow-up question just came in. If the rescheduling from a Schedule I to a Schedule III goes through, what will be the impact on the DOT regs and the FAA regs once that reclassification is made?
I'm sorry, what was the question again?
It says, how does the change from a Schedule I to a Schedule III impact both the DOT regs and the FAA regs?
I'm assuming that the DOT regs and the FAA regs are going to have to be modified slightly because we still have classifications. There are over-the-counter medications that you're not permitted to use from a DOT standpoint. So over-the-counter medications and actually prescription medications, I believe that the DOT regulations prohibit the presence of Tylenol with codeine or other Schedule III drugs within your blood. Therefore, I would assume that even if marijuana is rescheduled to a Schedule III, the rules would change perhaps on whether or not there's an immediate termination. But it still would probably be prohibited to have that substance within your system.
Okay, thanks. And I'm going to toss this one out to either Cliff or Mike Clark. You two can join together on answering this question. But currently, as the law exists in the state of Michigan at least, if an employer has zero tolerance drug testing policy, can an employee with a marijuana medical card be terminated if they test positive on a drug test?
Well, I guess I'll go first. The answer generally is yes, right? The general answer in Michigan right now is different than some states. We have our own statute that decriminalized marijuana. I mean, it did not make it legal, right, because it's still federally illegal. It's a Schedule I illegal drug. And what you basically have is a law that everybody's enforced. And what we look at right now is, do I have to give a person a reasonable accommodation for testing positive? And the answer is, under Michigan's law, it says, look, there's nothing that says you can't have a policy and a procedure and enforce your policy and procedure. If you say marijuana, if you test positive for it, can require you to be terminated. It doesn't matter what your argument is about, well, I had it in my system. I was secondhand smoke. It was 30 days ago. The policy is the policy. Now that could change. There could be another case that comes out that attacks it on a different grounds to say, oh, well, this person had a disability. You didn't go through the accommodation. But right now, there's no need to accommodate based on the federal law right here in our district, our federal district, for using a Schedule I drug. That's not a reasonable accommodation right now. And our law does allow you to do that. The question is going to be, will there be a change when it goes to Schedule III? Or if it goes to Schedule III, where this is something where you might have to do the accommodation, well, you will have to go through an accommodation analysis of whether or not the person was under influence. State could also modify our law. Some of the other statutes have certain rights in them. In California, as of January 1 of this year, they have a law that says, look, you can't use a test that tests for non-psychiatric or non-psychotropic metabolites, which means basically almost every test that we have right now can't be used to terminate somebody or to create some sort of adverse employment action. That's what they do in California. So if you have employees outside the state of Michigan that work for your Michigan-based company, you may have to watch very carefully, because applying our laws here in other states for other employees could get you in trouble pretty quickly, because not every state is on the same page as we are as far as being able to follow our drug testing policy.
Okay, and Mike Clark, let's look at public sector employees. Is there any differences between public sector employee rights and private sector employee rights with respect to drug testing, looking in particular at the search and seizure issues?
Well, with respect to many of the clients that I represent, which are both public, private, and so on, have commercial driver's licenses. Okay, so the CDL operators under federal law are governed by those standards. And so the public employers that I have clearly have the right to abide by the requirements of the federal government concerning the ability or inability of an operator of a commercial vehicle to have a controlled substance in their body. So, in my opinion, that applies both equally to private as well as public, and we follow for those commercial drivers the federal law, because it trumps, if you will, any other lower standard at this point.
Okay, great.
Hey, Mike, to piggyback on a little bit of that context, think about it in a collective bargaining setting, and I've seen this before. Let's just say you have a contract with a union, or you have a policy, whatever it might be, but a contract with union where you set, here's what the threshold rates for the test are going to be. If you test above this amount, we're going to consider you under our policy be under the influence, and you can be subject to discharge or any other discipline that you want to have. And let's just say you have a drug that was Schedule I that gets dropped down to Schedule II. So I'll give you an example of a drug that, in the last couple of years has really been used more. And there's been an initiative to try to let people use it in the workplace, and that's methadone. You have a lot of people that are addicts. They're trying to get off the hardcore drugs that they're on, get their life turned around. And the federal government's really pushing to make sure that even if you negotiated a certain level of methadone into your collective bargaining agreement, you got to be very careful, because just because you negotiated it doesn't mean it's lawful. That's like saying, I can't negotiate to pay you $4 an hour, right? I can't negotiate below the federal standards for the ADA. If that drug is allowed, non-marijuana, but that drug is allowed under the standards, you might now all of a sudden have a duty to engage in the interactive process, see whether or not it's actually impairing the person, whether the person has a medical requirement to have it. I mean, there's a lot more that has to go into it. So I think we have to be very careful. And a lot of times employees are saying non-DOT, federally required standards, let's just drop marijuana from our testing. There's nothing that says you have to have marijuana on your pre-employment screen. But your workers' comp insurance might be fighting with you saying, what are you doing? You got to put that on there. It's going to have more accidents. So there has to be some thought processes. So just because you can do something doesn't mean you necessarily have to, but just because you want to do it doesn't mean necessarily that if you have a federal contract or if you have a DOT covered person, not every employer and every job position is going to be exactly the same. That's why you got to make sure you're constantly reviewing what's in your policy, what drugs are you using, and how are we testing it. It's not a static, it's done, here's a template, and we're good for 50 years. And right now, we're really in a static, or not in a non-static phase. It's fluctuating.
Okay, thank you.